To discuss all of this and more, we have with us Ralph Wilde, who's a professor of international law at University College London. He also served as senior counsel on behalf of the Arab League at the International Court of Justice. And Ralph, you argued that Israel's presence on the occupied Palestinian territories is illegal. You're joining us from Montevideo this hour. Thanks for your time. If we can start with the recent comments made by the U.S. envoy Steve Witkoff, and he said that there's no starvation in the Gaza Strip, only a food shortage, basically refuting what we hear from many organizations on the ground and eyewitness accounts. Legally speaking, how does this framing obscure the reality under international law?
Thank you. I should stress I'm here speaking in a private personal capacity only. So in international law, Israel's presence in Gaza is, along with its presence in the West Bank, in and of itself illegal, as a violation of self-determination and a violation of the law on the use of force. So it's an aggression. In consequence of that, Israel has no legal right even to be there in the first place, and therefore, in consequence, no legal right to operate any restrictions preventing others, whether the United Nations, states, other aid organizations, NGOs, from entering Gaza and providing aid. Now, although Israel's authority over Gaza is illegal, because it nonetheless exists, as a matter of fact, Israel is defying its legal duty to withdraw. Israel then has an international law obligation to ensure that the Palestinian people of Gaza do not starve. The only way it can discharge that legal obligation is to either withdraw completely, as I say it's legally required to do, or if it maintains that illegal presence, either to provide the necessary aid itself or allow others to do so. Israel is doing neither of those things. It's preventing others from providing the necessary levels of aid, and it's running with the US this sham operation, which of course is fooling no one, providing only a fraction of what is needed, and as if this was not illegal in and of itself enough, also doing so through this sadistic Hunger Games style process where people risk being killed or at least maimed by the very actors from whom they must obtain food. Now, given that Israel and the US, who are doing this jointly, of course, have made this choice when there are other alternatives that I've mentioned possible, the situation meets the legal test in international law for what is referred to, and I'm quoting here from the Rome Statute for the International Criminal Court, intentionally using starvation of civilians as a method of warfare by depriving them of objects indispensable to their survival, in this case, of course, basic foodstuffs and medical supplies, including willfully impeding relief supplies. This is a serious violation of the laws of war on the part of Israel and the US, and for all those people involved in it, the mercenaries working for the GHF, the Israeli soldiers operating with them, the leaders of Israel and the US who've decided on and implemented this policy, it is a war crime. So, also, very importantly, it is not only a war crime, it is also a crime against humanity, and it is part of genocide. Because in the case of genocide, because it involves, of course, the deliberate infliction of conditions of life on the Palestinian people, starvation, calculated to bring about their physical destruction.
Okay, you've answered my question about whether this constitutes starvation, constitutes a weapon of war under the legal kind of definition. So let me ask you this: you've outlined a variety of ways in which Israel, as well as the U.S., are basically violating international law right now. What avenues are there for accountability? I mean, we saw that ICJ ruling, didn't we, that said Israel is committing plausible genocide and must take steps to prevent it, but that hasn't happened.
So because the violations of international law committed by Israel and the US in Gaza and the West Bank are of the fundamental rules of international law: the prohibition of aggression, the right of self-determination of the Palestinian people, the prohibition of genocide, the prohibition of serious violations of the laws of war, which, if violated, constitute war crimes, the prohibition of crimes against humanity, and torture, racial discrimination generally, and apartheid in particular. Because those violations are in a special category in international law, all states have positive obligations in international law to take action to bring those violations to an end. And they must take every mechanism available to them as a matter of legal obligation, not as a matter of discretion. So that requires sanctions against Israel, full spectrum efforts by states to restrict their engagement with Israel as a means of attempting to try to influence its behavior.
Mr. Wilde, just a final thought from you, if I may, on something that you've written about. And you've written about the legal basis for recognizing Palestinian statehood with the Montevideo Convention as a reference point. Can you explain why recognition would not be contrary to international law, as some have been saying recently? So I'm speaking to you from Montevideo. And it's important to, first of all, to clarify, the Montevideo Convention was a treaty in the 30s signed by a group of states from this region. It's not binding on states generally in international law, but it reflects certain principles which are relevant to Palestinian statehood, but not the full picture. So the Montevideo criteria are limited to establishing essentially the viability of the Palestinian state. Is there a territory? Is there a population? Is there a government exercising control over that territory and population? And does it have the ability to engage in international relations? However, in the case where the group in question, here the Palestinian people, have a right of self-determination, the legal developments that took place in international law after the Montevideo Convention was agreed in the 30s, so after the Second World War, the right of self-determination, that changed the position in international law, creating an entitlement on the part of people who have a right of self-determination to constitute themselves as a state if that is their choice. And that's an important additional factor that means Palestine now does meet the legal test for statehood. Also, if that weren't enough, which it is, more than 3/4 of the world's states, the members of the United Nations, so around 147 states out of 193, have recognized Palestine as a state. And in international law, recognition can also play a role in establishing statehood legally. Right.
So for those states who have not recognized Palestine as a state yet, they would simply be recognizing a pre-existing reality. And manifestly then, that would not be illegal, quite the contrary. And indeed, to do that recognition, they would be taking a positive step to affirm Palestinian self-determination. And last year, the International Court of Justice reminded the states of the world that in cases of violations of self-determination, as in this situation, all states have a positive duty to bring that violation to an end. So just as they have a positive duty to end Israel's violations of those other areas of law that I mentioned before, in notably when it comes to the genocide in Gaza, which concern the Palestinian people,
Right.
they also have a positive obligation to bring Israel's impediment to the realization of Palestinian self-determination to an end. And one concrete way that they can do that, and that's why many states have recognized Palestinian statehood, is by recognizing Palestine as a state.
Okay, we'll have to leave it there. Ralph Wilde, you're a professor of international law at UCL. Thank you so much for speaking to us this hour from Montevideo.